Hi everyone, my name is Haroop Boldukian. I'm a practicing bankruptcy attorney here in the state of California. And in this video, I want to go over some reasons why somebody might not want to file for a Chapter 7 bankruptcy. The first reason why somebody might not want to file for bankruptcy protection are unprotected assets. In a Chapter 7 bankruptcy, you're listing your assets in your paperwork. Your assets are your stuff, anything that you own, that you are entitled to, anything that you have the right to sell, to claim money to, or has a value to you. Those are assets that need to be disclosed in your bankruptcy. Anything from your car, to your house, to your checking accounts, even that cryptocurrency wallet, all of those are assets that need to be included in your Chapter 7 bankruptcy. A lot of the assets that you have will have protections. Those protections are called exemptions. A lot of you might have heard of what's called the homestead exemption that protects value in your home, but there are state exemptions here, especially in California. Every state has their own set of exemptions that protect assets like equity in a home, motor vehicle, your jewelry, your household goods and furnishings, your personal clothing, your checking account, your retirement account. There are specific exemptions to protect certain assets. So you want to talk to a bankruptcy attorney to go over those exemptions with you and pair them up with the assets that you have. It's very important for you to disclose your assets because you're signing in everything under penalty of perjury, and you want to make sure that there is no exposure. A lot of the times at a Chapter 7 bankruptcy hearing, the trustee will tell you that their main job is to look for exposed assets in your case so they can sell those assets and they can pay off your creditors. A lot of times what they're looking for is exposure. They know that there are exemptions out there. A lot of people that end up filing a Chapter 7 bankruptcy end up filing what's called a no asset bankruptcy, meaning that all the assets they do have, all the stuff that they do own are protected. In those cases, you don't run the risk of having to pay into your bankruptcy case at all. The trustee will just kind of sign off that they did their part by asking you your questions, making sure the information is true and correct. But what happens when you have an unprotected asset? Well, the trustee in that case will likely either want to sell that asset or is willing to negotiate with you to pay into your case. For example, let's say you have a couple cars, one of them has a loan against it, and there's really no value in that car. The other car is fully paid off, and the motor vehicle exemption only protects a certain portion of it. So let's say there's an exposure of about $4,000 or $5,000. The trustee is going to want that $4,000 or $5,000. A lot of times you're able to negotiate with the trustee to pay into the case that $4,000 or $5,000 that's exposed, and the trustee will use those funds to pay off your creditors. Another reason why you might not want to file for a bankruptcy or a Chapter 7 bankruptcy are payments to family members. You know, you're thinking about filing for bankruptcy, you've fallen on hard times, you're unable to pay your debts, you have a hard time keeping up with rent, keeping up with car payments, keeping up with the ongoing monthly expenses, with prices of groceries going up and cost of living going up all over the place. Keeping up with those credit cards can be hard. So it's very normal for you to turn to your family to help you. A lot of times a family member might loan you some money so you can keep up to date, may help you with rent and so on. But those are loans to your family that do need to be paid back. They're a creditor just like anybody else. So if you pay back those loans first before paying back any of your creditors, that's actually what's called a preferential payment. That can actually be undone in a Chapter 7 bankruptcy, where the trustee can go after that family member and get that money back that you paid them. The trustee can use those funds to pay back your creditors in a fair way. That's going to make things a little bit awkward at the next family get together if you're paying back a loan and then filing a Chapter 7 bankruptcy. So if you've paid back a loan within the last year and you're thinking of filing for a bankruptcy, you definitely want to talk to your attorney about how you want to disclose that. A lot of times a family member, it's more appropriate to list them as a creditor just to show that you want that debt discharged as well. Otherwise, you're running the risk of a preferential payment where, again, the trustee's going to get involved. They're going to go after that family member where you repaid that loan, and that family member is probably not going to be very happy with you. Third reason why you might not want to file for a Chapter 7 bankruptcy is transferring assets out of your names. Now, I can't tell you how many times people have called me during our consultation. They say, oh, I have this car, oh, I have this house, but I'm just going to put the car in my son's name, or I'm just going to give the house to my brother just so I don't have to deal with it in the bankruptcy. Well, you can transfer assets out of your name, as long as there is full consideration, meaning that whoever you sold it to, whoever you transferred it to, paid you the full market value of whatever that asset is. But if you're simply trying to dump assets out of your name to try to file or qualify for a Chapter 7 bankruptcy, that's basically a fraudulent transfer. That can be prosecuted by the United States Trustee's Office. Chapter 7 trustee is definitely not going to be happy with you. They can essentially undo that transfer and go after that asset knowing that it was transferred prior to the filing of your case. It gets a little bit tricky. You definitely want to talk to an experienced bankruptcy attorney about that process. You're certainly not going to be doing yourself any favors by dumping assets out of your name simply to qualify for a Chapter 7. So if you've transferred assets out of your name recently, it's probably not a good idea for you to be filing a Chapter 7 bankruptcy. A fourth reason why somebody might not want to file for a Chapter 7 bankruptcy is if that debt was incurred by fraud. Now, there's some debts that are non-dischargeable in a Chapter 7 bankruptcy. We know that certain taxes are not dischargeable. Student loans, for a large part, are not dischargeable, but there are guidelines that has helped individuals discharge part, if not all, of their student loans. Domestic support obligations are not dischargeable, but debt incurred by fraud is also not dischargeable. But let's say you were involved in a lawsuit and they obtained a judgment against you, and one of the causes of action was fraud or misrepresentation. That judgment or that debt that's owed that was incurred by your fraud or misrepresentation is not dischargeable in a bankruptcy. Even personal injury, if you injured somebody, if you punched somebody, or if you hit somebody, it was an intentional tort. You caused harm to somebody intentionally, their person or their property, and they obtained a judgment against you, or if you're being sued for that wrongdoing, essentially that debt is not going to be dischargeable in a Chapter 7 bankruptcy. So that's when you definitely want to speak to a bankruptcy attorney to fully understand why you might be filing. Now, the Chapter 7 bankruptcy may slow down that lawsuit, may stop it, but it's certainly not going to make that debt go away. And a lot of times you can expect that creditor to follow you into the Chapter 7 and possibly file an adversary proceeding, which is basically another lawsuit inside of your bankruptcy. So we've gone over some of the reasons why you might not want to file for a Chapter 7 bankruptcy, whether it's unprotected assets, whether it's debt incurred by fraud, whether it's transferring an asset out of your name shortly before filing, or it's paying back loans to family members over other creditors. So what do? If you can't file for a Chapter 7 bankruptcy, you can definitely file a Chapter 13. It's called a reorganization. What you're doing is you're taking the debt that you owe, that we know can't be discharged, or for whatever reason, that debt is not going to go away in a Chapter 7, and you're reorganizing it in a Chapter 13 plan. The Chapter 13 payment plan is usually a 3 to 5 year plan. Your attorney can go over with you what that means exactly. There's certain qualifications that still apply in a Chapter 13, but what you're doing essentially is, instead of getting a discharge in a Chapter 7, you can at least control the payment of that debt in a Chapter 13 bankruptcy.